Senator Tim Kaine pressed a Virginia prosecutor over whether immigration considerations influenced a controversial plea deal involving an undocumented immigrant accused of sexually assaulting a minor. The hearing became increasingly tense as the attorney repeatedly avoided giving a direct yes or no answer.
Thank you, Mr. Chairman, for holding this hearing on a really important issue that I think a lot of Americans care very deeply about. Mr. Descano, I want to start with you. I've got a couple questions for you. I've got a document titled Guidelines for Plea Bargaining Charging Decisions and Sentencing. And it states that prosecutors shall consider the collateral immigration consequences of the specific crimes the defendant is charged with and the detrimental impact the deportation removal has on the families and community. Not from your campaign website. This is the official policy document as well. Is that correct? Do you recognize this?
Yes, you read a portion of the policy, sir.
That's right. I'm not going to read the full thing.
I don't expect you, sir.
It's about 11 pages. I'm not going to read the full thing. I want to better understand how you weigh an illegal alien's immigration status whenever you're making charging decisions. Do you know who Ander Jose Cortez Mendez is? Are you familiar with that case?
Yes, sir.
Okay, this is a Guatemalan illegal alien who was arrested in March of 2024. He was initially charged with, quote, carnal knowledge of a 13 to 14-year-old. Just for those of us who aren't lawyers, can you describe just very briefly what does carnal knowledge of a 13 to 14-year-old mean in this context?
Well, sir, generally a charge like that would typically refer to underage sex.
Okay, so he raped an underage person, an illegal alien who raped an underage American. Your office reduced those charges to a misdemeanor charge of consensual sex with a child 15 years and older. You offered him a 90-day suspended jail sentence. Is that correct?
Sir, based on the evidence that we had in the case?
So it is correct.
But it's not related to the policy, sir.
So that is correct. I just want to ask you, whenever you were making that charging decision to reduce the charge, how did you weigh the defendant's immigration status?
Well, sir, to be clear, I was not the lead prosecutor in that case.
It was your office.
Oh, absolutely, sir. I, of course, rely on my team of 50-some attorneys to do cases. But I think what is important is that oftentimes, as you know, sir, as a prosecutor, you know, we're constrained by the evidence. We're constrained.
I just need to know how did you take into account the defendant's immigration status?
Well, sir, again, I'm saying
making that decision. How did your office make that determination?
Well, what I would say is that, and thank you for clarifying. If you take a look at the immigration consequences policy, or
let me ask it a different way. Did your office reduce charges against this illegal alien from a felony rape charge to a misdemeanor charge with a 90-day suspended jail sentence, in part because this was an illegal alien in question?
No, this was evidentiary based.
It was it had nothing to do with the defendant's immigration status.
So if you read the policy, you'll see that.
Did it have anything to do with the defendant's immigration status? It's just yes or no.
Well, sir, it was based on the evidence.
I'm asking you, was their immigration status part of the evidence?
I don't believe so.
Yes or no? You don't believe so. Your policy says that you shall consider their immigration status.
Sir, if you actually read the whole policy, it explicitly carves out cases.
Prosecutors shall consider the collateral immigration consequences of the specific crimes the defendant is charged with and the detrimental impact the deportation removal has on the families.
It also mentions that it's not outcome determinative. It also
I understand, and I'm asking you if your office weighed the defendant's immigration status in making your charging decisions here.
Oh, again, sir, I was not the lead prosecutor in this case.
I'm asking for your office. I understand you're not the lead.
Exactly. I just want to be clear. But the way that the policy is written, that case should not have fallen under the rubric of this policy. This is a narrow policy and is meant to be a narrow policy.
It's an illegal alien, I think that would qualify, would it not?
Well, no, sir, because again, the way that the policy is being presented as it is outcome determinative.
There would be immigration consequences based on what charge you bring. That would clearly apply to this case.
No, sir. Again, that's the reason why I mentioned earlier, you read a portion, but not the entire 2 paragraphs of this subhead.
Prosecutors shall consider. I just want to know, just give me a yes or no answer. Did you take into account the defendant's immigration status?
Sir, again, I was not, but the way the policy,
did your office
is written, no, they should not have taken.
They should not have.
That is not outcome determinative in a case like this, sir.
Great. Thank you. My time's up.
Mr. Grothman.
Yeah, I had another hearing, so I apologize if I'm...
This was one of those hearings where the tension didn't come from shouting. It came from the refusal to give a straight answer. The central issue here was simple but politically explosive. Did prosecutors reduce charges against an undocumented immigrant partly because they were considering the immigration consequences of the case? The senator walked into the hearing armed with a policy document from the prosecutor's office itself. The document explicitly stated that prosecutors should consider collateral immigration consequences when making plea bargain and charging decisions. That immediately set the stage for the confrontation. Then came the specific case. The senator referenced a Guatemalan national accused in 2024 of having sexual relations with a minor between 13 and 14 years old. According to the questioning, the original felony charge was later reduced to a misdemeanor with a suspended 90-day sentence. That's what transformed this from a technical legal discussion into a politically explosive moment. The senator's strategy was straightforward. Force the prosecutor to answer one very direct question. Was immigration status considered when the charges were reduced? But the prosecutor never fully gave the clean yes or no answer the senator wanted. Instead, he repeatedly shifted back to talking about evidentiary limitations, saying prosecutors are constrained by the facts they can prove in court. That's a standard legal defense prosecutors often use when defending plea agreements, because criminal cases frequently end in negotiated settlements rather than full trials. But politically, that answer wasn't satisfying to critics. Why? Because the written policy itself clearly mentions immigration consequences as something prosecutors shall consider. So, from the senator's perspective, the prosecutor was trying to separate the office's policy from the actual decision-making process in a case where immigration status obviously existed. The prosecutor tried to argue that the policy was being mischaracterized and that it was intended for narrow circumstances, not as an outcome-determinative rule. In other words, he claimed immigration status alone should not decide the outcome of a case. But the hearing became increasingly uncomfortable because every time the senator asked, "Did immigration status play a role?" the answer circled back to technical explanations instead of a direct denial.